everyone, welcome back to the channel EduTap. I am Arshdeep Kaur and today we will be starting with another act, that is the Sales of Goods Act. We will be doing the important provisions of Sale of Goods Act through MCQs. Before I start, I would like to tell you that EduTap has come up with test series for both the phases, phase 1 and phase 2. It will include chapter-wise tests, sectional tests and full-length tests. It is going to be very helpful for your revision. We have also come up with live crash course for both the phases, phase 1 and phase 2. It will have live classes. We are giving you more than 60 live classes and it will be 2 hours each. It will also include the test series I have just mentioned, and you also get one-on-one mentor support. So if anyone who is interested can refer to the link in the description below. Let's start with the lecture. Before I start with the question, you must know that the Sale of Goods Act was actually a part of Indian Contract Act 1872. But in 1930 it was taken out, it was made into a separate enactment, and now it is Sales of Goods Act 1930. So earlier it was a part of the Indian Contract Act. So it was included in the chapter 7 of the Indian Contract Act, and the sections 76 to 123, they dealt with the Sales of Goods Act in the Indian Contract Act. The general provisions of the Contract Act, that is from section 1 to 75, they are applicable on the Sale of Goods Act. The contract of sale will be in accordance with the provisions of the Contract Act, and then once the contract is made, now we have to see that how the sales agreement or how the sales contract has to be executed. Now that is the subject matter of Sales of Goods Act. So let's start. Goods are defined under the Sales of Goods Act 1930 as. So the answer for this is option A. They are tangible, movable property, right? So the subject matter of a contract of sale, that is between the buyer and the seller, the subject matter is goods, right? So the goods has been defined in section 2.7. This is very important definition. You must know each and every word, what it means and what it says, right? So let's start. Goods mean every kind of movable property. So goods mean every kind of movable property. So the first and the foremost principle is that every movable property is goods, right? So what is a movable property? Movable property has not been defined in the Sales of Goods Act, and if it is not defined here, we have to move to the General Clauses Act, right? So what does General Clauses Act say? General Clauses According to the General Clauses Act, movable property is the property which is not immovable. So every property which is not immovable is movable property according to the General Clauses Act. But this does not clear anything. So now we need to know that what is immovable property. Again, we would have to move to the General Clauses Act, and according to the General Clauses Act, it includes land. So first is that immovable property includes lands. Thing affixed to earth, anything that is affixed to earth, which means that anything that is affixed to earth, for example the trees, for example your buildings, for example your house, right? Or permanently fastened to anything affixed to the earth. Permanently fastened to, for example, if we are talking about a house, so that means the doors, the walls, the windows, they are permanently fastened, right? So permanently fastened to anything affixed to earth, and any benefits arising out of the land, and any benefits that are arising out of the land, it forms what? It forms the immovable property. So anything which is not immovable property is movable property. Now we are clear that what is movable property. Now the goods, what are goods? So good means every kind of movable property, but other than actionable claims. That means the actionable claims, they do not form a part of goods, right? So actionable claims are not goods. So now the question arises that what is actionable claim? So actionable claim is basically a type of debt which is unsecured, right? For example, A gives money to B, he gives 1000 rupees to B without any security, right? So here A's claim, here the A's claim to ask for money from B, it is his right, it is his claim. Now he can, what he can do, he can move to the court if B does not pay on time, for example. So this is his actionable claim, right? It is without security. If it is with security, in case of immovable property, it would be mortgage. In case of movable property, it would be pledge. So that is why it is unsecured debt. So any actionable claim, it is related to a debt which is unsecured, right? So this claim, that the actionable claim, this is not included in the definition of goods, right? Other examples of an actionable claim could be, for example, you have not received your salary for 4-5 months, right? So this is your actionable claim. You can move to the court. You can move to the court. This is what? This is your actionable claim. So employee's right to salary, it is what? It forms actionable claim. So actionable claim is not considered to be a good. Actionable claims and money. Money is also not included in goods. Money is what? Money is the consideration. It will be consideration in the contract and it is not included in goods. But there can be some rare exceptions to this also. For example, you must have seen that the rare coins, rare ancient coins, they are sold for very high value, right? So that in that case it could be goods, but the journal principle says that actionable claims and money, they are not goods. And includes. Now we'll be talking about what it includes. So it includes stock and shares. Goods include stock and shares. Growing crops. Growing crops, because growing crops are included? Because whenever someone grows crops, their intention is always to separate it. Their intention is always to harvest it and then sell it, right? So that is why the growing crops, they are goods. Grass and other things attached to or forming part of the land which are agreed to be severed before sale or under the contract of sale. So any such thing which forms a part of immovable property, but before the contract or on the contract it is agreed upon that it will be separated from the immovable property and it would be sold, it is what? It is goods, right? Now we read the entire definition. It will be clear to you. Goods mean every kind of movable property other than actionable claim or money, and include stocks and shares, growing crops, grass and things attached to or forming a part of the land, which is forming a part of the land but which are agreed to be severed, right? It is agreed that it is going to be separated from the earth before sale or under the contract of sale. So this is what goods mean, and goods are the subject matter in the contract of sale, right? Moving on, question number 2. Which of the following is an essential element of a contract of sale? Sale, consideration, goods, both A and B, or all? So the answer is all. All these form an essential part of the sale of contract. Let's read section number 4. Section number 4 is very important. A contract of sale of goods is a contract whereby the seller transfers or agrees to transfer the property in goods. So when I say transfer property in goods, what does that mean? That what we are transferring here, we are transferring the ownership. So if we are transferring the ownership in sales, we are only transferring the ownership in the goods, right? So the seller transfers, either he is transferring immediately or agrees to transfer, or he is agreeing to transfer it, right? So the seller transfers or agrees to transfer the property in goods, that is the ownership in the goods, to the buyer for a price. That means it should be for a consideration. There may be a contract of sale between one part owner and another, and there can be a sale, there can be a contract of sale between one part owner and another part owner. For example, that A and B, they jointly buy a car. Now A says that I want to give up my share of that car, right? And B says, okay, I'm ready to buy it. In that case, both were the owners, and now one becomes the seller and one becomes the buyer. This is what they are saying. There may be a contract of sale between one part owner and another. A contract of sale may be absolute or conditional. It could be absolute or it could be dependent on a condition as well. So it can be absolute also and it could be conditional also. Where under a contract of sale, the property in the goods is transferred from the seller to the buyer, the contract is sale. If the transfer of property is happening immediately, then in that case, it is termed as what? It is termed as sale. But where the transfer of property in the good is to take place at the future time, but where it has to take place in a future time, right? If it takes place in a future time or subject to some conditions, it could be time bound, like it will happen after 3 months, or it could be dependent on a condition. In that case, thereafter to be fulfilled, the contract is called agreement to sell. So if it is happening immediately, it is sale, and if it is dependent on a condition, or if it is happening in future, the parties have just agreed, then it is what? Then it is agreement to sell. Agreement to sell. An agreement to sell becomes a sale when the time elapses. So whatever the time period was, whenever it elapses, it becomes what? It becomes sale, or the conditions are fulfilled, or whatever the condition was, if it is fulfilled, then also it becomes a sale, subject to which the property in the goods is to be transferred, right? So this is sale and agreement to sell. This is given in section number 4. Moving on, question number 3. According to Sale of Goods Act 1930, a contract of sale may be expressed or implied, written or oral, both A and B, none of the above, either expressed or written. The answer is C. It can be expressed or implied, it can be written or oral. There is no hard and fast rule, right? A contract of sale is made by an offer to buy or sell goods for a price. So here the concept of offer and acceptance comes, right? So a contract of sale is made by an offer. First of all, someone is giving an offer that I want to buy or I want to sell this good. For a price, there has to be a consideration and the acceptance of such offer. And when such offer is accepted, it becomes a contract. The contract may provide for the immediate delivery of the goods or immediate payment of the price or both. So anything, whatever they decide, it is according to the parties, or for the delivery of the payment by installments. It could be by installments as well, or that the delivery or the payment or both shall be postponed. So whatever the parties decide, it is going to be valid, right? Subject to the provisions of any law for the time being in force, a contract of sale may be made in writing or by word of mouth, or partly in writing and partly by word of mouth, or may be implied from the conduct of the party. So it could be in writing, it could be oral, it could be partly in writing, it could be partly oral, it can be anything, whatever the parties decide. But it says that it is subject to the provisions of the law. So what does this mean? So if, for example, in any law it is given that a sale of sugar can only be made by a written contract. So if any law says this is just an example, right? So in that case, whenever a contract has to be formed for the sale of sugar, it has to be in writing. So that is why it is written subject to the provisions of any law for the time being in force. So right, that law is going to prevail. But if no such law exists, then a contract of sale may be made in writing or by the word of mouth, or partly in writing and partly by word of mouth, or may be implied from the conduct of the parties. Question number 4. The Sale of Goods Act 1930 provides that the price in the contract of the sale may be. So the answer to this is D. It can be fixed by the seller, it could be fixed by the buyer, or determined by the course of dealing between the parties, right? So where it is given in section 9, that is ascertainment of price. The price in a contract of sale may be fixed by the contract. It could be fixed by the contract, that is, it could be fixed either by the seller or it could be fixed either by the buyer, or may be left to be fixed in the manner thereby agreed, or they can leave it and they can agree upon that it will be decided according to a certain manner, or may be determined by the course of dealing between the parties. Or they could decide that we will do our business and we will decide it accordingly, right? We will decide it in the course of the business, right? So determined by the course of dealing between the parties. Where the price is not determined in accordance with the foregoing provisions, and where no such thing has been decided, the buyer shall pay the seller a reasonable price. There the buyer has to do what? He has to give the seller, he has to pay the seller what? A reasonable price. And what a reasonable price in question of fact, dependent on the circumstances of particular case. And what is a reasonable time? This we have done in contract also. It is a matter of fact, right? So a reasonable price is a question of fact. Question number 5. The Sale of Goods Act 1930 provides that the buyer is deemed to have accepted the goods when. So when it is deemed that he has accepted the goods, the answer is D, all of the above. That is, the buyer expressly indicates the acceptance. The buyer fails to reject the goods within a reasonable time. The buyer uses the goods, right? So all these things, if he does any of these things, it means that he has accepted it. It is deemed that the buyer has accepted the goods. Acceptance has been given in section 42. Very simple section. Let's read it. The buyer is deemed to have accepted the goods when he intimates to the seller that he has accepted them. So when he intimates the seller, he tells him that I have accepted the goods. Expressly telling him I have accepted the goods. This is valid acceptance. Or when the goods have been delivered to him and he does any act in relation to them which is inconsistent with the ownership of seller. So if he does any act which is inconsistent with the ownership of seller, for example, he pledges the goods, he sells them again, okay? He is reselling the goods. So what is this? This is something inconsistent with the ownership of the seller, right? So this is what this is deemed to be acceptance. It will be deemed that the buyer has accepted these goods. or when after the lapse of a reasonable time. After the lapse of a reasonable time, he retains the goods without intimating to the seller that he has rejected them. So if he does not intimate the seller within a reasonable time that he has rejected these goods, it will be deemed that he has accepted the goods, right? Very simple. Now let's read it once again. It will be very clear. The buyer is deemed to have accepted the goods when he intimates to the seller that he has accepted them, or when the goods have been delivered to him and he does any act in relation to them which is inconsistent with the ownership of the seller, or when after the lapse of a reasonable time he retains the goods without intimating the seller that he has rejected it. Right? Question number 6. When the seller delivers a larger quantity of goods than what was ordered. So what can the buyer do in case he receives larger quantity of goods than he has ordered? Accept the entire quantity and pay for the excess, reject the entire quantity, accept the ordered quantity and reject the excess. Now, both or all of the above. The answer is E, all of the above. He has all these options. It has been given in section 37, clause 2. Let's first read it. So, where the seller delivers to the buyer a quantity of good larger than contracted to sale, the buyer may accept the goods included in the contract and reject the rest. So whatever he has ordered, he can accept them, and the rest he can reject them, or he may reject the whole. So here the students get confused, right? So he also has an option to reject the entire quantity, right? So he has this option also. He can reject the entire quantity, that is, he can reject the whole. If the buyer accepts the whole, and he also has the option that he can accept the whole. So, but if he accepts it, then the goods so delivered, he shall pay for them all the contract. He shall pay for them at the contract rate. So, if in case he is accepting the whole of the quantity, in that case, he is going to pay according to the rate of the contract that was agreed upon, right? So, where the seller delivers to the buyer a quantity of goods larger than he contracted to sell, the buyer may accept the goods included in the contract and reject the rest, or he may reject the whole, or if the buyer accepts the whole of the goods so delivered, he shall pay for them at the contracted rate. Question number 7. When goods are sold by sample, the bulk is required too. The answer is D, all of the above. We will straight away move to the section, right? So sale by sample, it has been given in section 17. A contract of sale is a contract by sale of A contract of sale is a contract for sale by sample where there is a term in the contract express or implied to that effect. So where it is expressly mentioned that this is a sale by sample, it will be a sale by sample, or it could be impliedly also. How it could be impliedly? For example, that this buyer and seller, they have been in this relationship of buyer and seller for so long. They have been in this relationship for say 5 years, right? And they have been dealing with the goods by sample only. They have been entering into a contract of sale by sample only. So this is going to be implied, even if in the 6th year they do not expressly mention it. So this is what, this is by their conduct. It has been happening like this, and it will happen in the 6th year also like this. So it can be expressly also, and it can be impliedly also. Second, in the case of a contract of sale by sample, there is an implied condition, and there is an implied condition. What are these implied conditions? That the seller has to fulfill. That the bulk shall correspond with the sample in quality, right? So the sample they are providing, it should correspond with the bulk. That is, the bulk is what? The bulk is that you have ordered. The goods that you have ordered, it is termed here as bulks, right? So the bulk has to correspond. It should be similar. It should be same as what? As what the sample was. So it should match the quality of the sample, right? So the bulk shall correspond with the sample in quality. That the buyer shall have a reasonable opportunity of comparing the bulk with the sample. Okay? It has to be that is, the seller, he has to give a reasonable opportunity to the buyer, that he can check, that he can examine the bulk, and he can what? He can compare the bulk with the sample. He has to be given a reasonable opportunity. That the goods shall be free from any defect. That the goods are free from any defect. They could be latent defect also, they could be patent defect also. So they should be free from both the type of defects, rendering them unmerchantable. What is merchantable quality? Merchantable quality is something that is easily accepted in the market, right? So it should not have any defect which makes it unmerchantable. It is let's read it again, that the goods shall be free from any defect, rendering them unmerchantable, which would not be accepted on, which would not be apparent on the reasonable examination of the sample, which was not in the sample, it should not also in the bulk. So it should be defect free, right? It should not render it unmerchantable. It should be something that is easily acceptable in the market, right? So if any of this implied condition, is breached, then the seller can be held liable, right? He is responsible in this case. Question number 8. Which of the following is not a condition under the Sale of Goods Act 1930? The answer is condition as to the price, right? So price is not considered a condition under the Sales of Goods Act. It is an essential term of contract, but not specifically categorized as a condition. Question number 9. The Sale of Goods Act 1930 provides that an unpaid seller can exercise the right of stoppage in transit if. So when can the seller exercise his right of stoppage in transit? We will be dealing with this, that what is stoppage in transit. So the answer here is if the buyer becomes insolvent. Only and only if the buyer becomes insolvent. Right of stoppage in transit. Subject to the provisions of this act when the buyer of goods become insolvent. So the condition is that the buyer has become insolvent. The unpaid seller who has parted with the possession of the goods. Parted with the possession of the goods, it means that he has given up his possessory rights. He has given up the possession, and it is in transit. It is in the transit means that it has not yet reached buyer, right? If it is not with the seller, if the possession is not with the seller, if it has not reached the buyer, so it is in transit, right? What does that mean? It is in transit. ठीक है, जैसे हम बोलते हैं रास्ते में है, right? So it is in transit, right? Who has parted with the possession of the goods has the right to stopping them in transit. That is to say, he may resume possession of the goods. So he can do what? He can resume the possession. He can take possession in that case. So what is happening here? For example, A is a seller and he is delivering the goods to B. So he calls a carrier and he says that please deliver these goods to C. But the goods are where? The goods are with the carrier only right now, right? And A comes to know that B has become insolvent. In that case, what he can do? He can call the carrier and he can say that bring the goods back, and he can take the possession of the goods, right? So this is stoppage in transit. He may resume the possession of the goods as long as they are in the course of transit. But the condition is they must be in the course of transit. They must not have reached the buyer, right? And may retain them until the payment or tender of the price. And he can ask the buyer that I will deliver the goods to you, but first you make the payment. So this is stoppage in transit. I was talking about the carrier, right? There could be 3 conditions of the carrier. Please understand, this is very simple. So first condition is, for example, if the carrier is the agent of the seller. If the carrier is the agent of the seller, so can he stop his goods in transit? The answer is no. Because the agent of the seller means that who has the constructive possession. It may not be the actual possession, but the constructive possession lies with the seller only, because the carrier was who? The carrier was the agent of seller. So in this case, he cannot exercise his right under section 50. He cannot exercise this right? But he can exercise his right of lien, but that is a different case. In this case, he cannot stop. He cannot stop it, right? Why cannot he stop it? He has not parted his ways with the goods, right? So it is in his possession only. He can retain them, but he cannot exercise this right. The other condition comes when the carrier is the agent of the buyer. In this case, what happens is, so in this case, whenever the seller handovers the goods to the buyer, it is deemed that the delivery has been complete. So in this case also, the stoppage cannot be exercised, right? This stoppage in transit, this right cannot be exercised, because as soon as the agent of this buyer, he takes the goods, it is considered that the delivery is good, and the question of the transit, the question of stoppage in transit, it does not arise, right? And the third could be carrier is a third party, and in that case, if the carrier is a third party, the seller can exercise his right to stoppage in transit while it has not reached the buyer, right? While it has not reached the buyer means it is in the transit. So I hope you are clear with this. Now let's read it. Now it will be very clear to you. Subject to the provisions of this act, when the buyer of the goods become insolvent. So this right, section 50 right, is only and only applicable when the buyer becomes insolvent. The unpaid seller who has parted with the possession of the goods has the right of stopping them in transit. That is to say, he may resume the possession of the goods as long as they are in the course of transit, and may retain them until the payment or tender of a price. Question number 10. When the ownership of the good is transferred from the seller to the buyer immediately at the time of the contract formation, it is known as, we have done this in the previous questions, it is known as sale. So the sale, in sale, it is immediately being transferred. In sale, the ownership of the good is transferred from the seller to the buyer at the time of the contract formation. Question number 11. Which of the following is not a right of the unpaid seller? So the answer is D. Right of refusal. Right of refusal is not a right given to the unpaid seller under this act. Unpaid seller rights, subject to the provisions of this act and for any law for the time being enforced, notwithstanding that the property in the goods may have passed to the buyer. So it does not matter if the ownership has been transferred or not, right? So notwithstanding that the property in the goods may have passed to the buyer, the unpaid seller of goods as such has the implication of law. So what rights does he have? A lien on the goods for the price while he is in possession of them. He has the right to lien, right? What is lien? A legal claim or right which is made against the assets that are held as a collateral for the satisfaction of the debt. So it is clear from this definition that in lien it is important that the ownership has been transferred, right? So he is holding to those goods as a security only, as a collateral of for what? For the satisfaction of his debt, right? So he can exercise what? He can exercise lien. But lien can only be exercised when he has the possession, right? So when he has the possession and when the property in the goods have been transferred, then only lien can be exercised. Now, while we were doing section 50, I told you that there could be 3 conditions with regard to the carrier option, right? So in case that the seller has parted his ways with the possession of the goods, but the carrier, he was the agent of the seller only. In that case also he can exercise lien, because who has the constructive possession? It is the seller only. So that is why the seller has the right to lien in that case also, right? In case the insolvency of the buyer, a right to stopping the good in transit after he has parted the ways with possession. This we have done in detail, section 50. A right of resale as limited by the act. So he also has a right to what? He also has the right to resale it. Where the property in goods has not passed to the buyer, the unpaid seller has. So where the property of goods, where the ownership has not passed, there is one more thing that the seller can do, which is in addition to his other remedies, a right of withholding the delivery. So he can do what? He can withhold the delivery and he can ask the buyer to make the payment and then only he will deliver the goods, right? So withholding the delivery, similar to and coexistive with the rights of lien and stoppage in transit where the property has passed to the buyer, right? So he has the right to withhold the delivery. This is also similar to lien only, but in this case the property in goods has not been transferred, right? Withholding of delivery is also termed as quasi-lien. It is kind of lien only, but the only difference, there is very thin line difference, and the difference is that the property in the goods, they have not been transferred, and in lien the property in the goods, they have been what? They have been transferred, right? Okay, next question. When the ownership of good is transferred from the seller to the buyer with the condition that it will revert to the seller upon the occurrence of the specified event, it is known as sale or return. It is sale or return, right? So in a sale or return arrangement, the owner of good is initially transferred to the buyer, but the seller retains the right to take back the goods if the buyer returns them within a specified period. Like for example, whenever you shop online, you always get this example, you always get this option, right? If you do not like the product, you return it, right? So the same is in this case, sale or return. In a sale or return arrangement, the ownership of goods is initially transferred to the buyer. They are transferred to the buyer, but the seller retains the right to take them back if the buyer returns them within a specified time. So it is within a specified time. If the time is not mentioned, it is a reasonable time, right? Next, when the ownership of good is transferred from the seller to the buyer at a future time or on the happening of a certain event, it is known as conditional sale, right? So in conditional sale, the ownership of good is transferred from the seller to the buyer at a future time or on the occurrence of a specified event. Very simple. Question number 15. Which of the following is not a type of sale recognized under the Sale of Goods Act? Sale by description, by sample, by auction or by advertisement? The answer is option D, sale by advertisement. So while the sale by description, sale by sample and sale by auction and sale by bulk are recognized under the Act, sale by advertisement is not specifically mentioned, right? So sale by advertisement is not a part of Sale of Goods Act. Now question for achievers. The Sale of Goods Act 1930 provides that the unpaid seller's right of lien is lost when the seller delivers the goods to the buyer becomes insolvent, it never ends, or both A and B. So you have to comment the right answer below. So that's all for today. I hope this was a helpful session for you. For more such videos, please like, share and subscribe to the channel EduTap. Thank you.